Tila napahiya at animoy mga estudyanteng nilektyuran ni Solicitor General Menardo Guevarra ang mga kongresista sa isinagawang pandinig sa Kongreso. Sinabi ni Solicitor General Guevarra sa hearing sa Kongreso na walang jurisdiction ng International Criminal Court para panghimasukan ang Bansang Pilipinas patungkol sa extrajudicial killing sa war on drugs na inuugnay kay dating Pangulong Duterte. Gumagana naman daw ang sarili nating criminal justice system sa bansa, kaya hindi nararapat na manghimasok ang ICC. Pahayag pa ni Solgen Guevarra na ang mas makakabuting gawin ng komite, ang lahat ng mga ebidensyang nakalap mula sa mga ginawang pagdinig ng komite ng Kongreso, ay i-turn over sa sarili nating executive agencies for appropriate investigation and prosecution, nandyan ang NBI, DOJ and Ombudsman na tamang ahensya para magsiyasat sa mga nasabing reklamo. Nang tanungin ni Congressman Lagman si Solgen Guevarra patungkol kay dating Pangulong Duterte at Senador Bato, kung may kaso na bang nakasampa laban sa kanila, sinagot naman nitong, walang kasong nakasampa, dahil wala namang nagsasampa laban kay dating Pangulong Duterte gayon din kay Senador Bato na dating PNP chief sa administrasyon ng dating Pangulo.
Si former President Duterte ba at sila, yung mga kanyang major correspondence ay meron ng prosecutor na Pilipino, prosecutorial office, na may nakapending na reklamo laban sa kanila, na iniusig?
As far as the former president is concerned, Your Honor, wala pa po, dahil wala pong nagpa-file ng complaint against him. Nung time na siya ay presidente, that's understandable, dahil siya po ay may immunity from suit. Pero ngayon po na hindi na siya presidente, wala namang nagpa-file ng complaint sa kanya.
Yung gobyerno ba mismo, yung prosecutor mismo, ay hindi pwedeng mag-file on their own sapagkat merong krimen na naganap sa Pilipinas under our laws and our international law?
Ang ating usual procedure po ay merong complainant, halimbawa yung biktima, kung sila po ay nag-allege na ang presidente ang siyang pasimuno ng lahat ng ito, ay sila po ang dapat na mag-file ng kaukulang complaint.
Motu proprio ang gobyerno, hindi pwedeng mag-file? Pinagbabawal ba yan?
Kasi po hindi po yun ang ating normal na proseso na mag-iimbestiga, magko-conduct ng preliminary investigation ang ating prosecutor nang wala namang nakahain na reklamo sa kanyang opisina. Ano po ang kanyang iimbestigahan kung wala naman pong nakahain na reklamo?
Okay. Yung bang ibang mga respondents maliban sa former president, wala rin kaso sa prosecution sa prosecutor's office?
Depende po sino po bang mga tao ang...
Si Senator Bato ba meron?
Wala po.
Wala
Naman pong nag-file ng any complaint against him.
Anong masasabi niyo mga kabayan, sa mga kabi-kabilang pagdinig na ginagawa ng Kongreso? Kung kayo ang tatanungin, papayag ba kayong panghimasukan ng ICC ang ating bansa? Gayong gumagana naman ang sarili nating criminal justice system.
We would like to recognize first... I'm sorry, go ahead.
May I ask the first question here for Congressman Lagman? I just would like to refer the question to a good friend of mine, Attorney Guevarra. All right, because you made mention that the withdrawal to the ICC is a political decision. So I would like to also be enlightened, being a non-lawyer, okay? Because a declaration of principles and state policies under the Constitution, where the Philippines adopts the generally accepted principles of international law as part of the law of the land and adheres to the policy of peace, equality, justice, freedom, cooperation, and amity with all nations. Is that also a political declaration?
I think so, Your Honor, because it's a declaration of policy.
Well, to me, that would be more questionable, Attorney Guevarra. No? What I'm saying is, when it comes to the Constitution, it is not just a political declaration. It is the Constitution.
Yes, Your Honor.
Now, I'm not a lawyer, but I understand it, that is not a political declaration. It is the Constitution we are talking about. But you are referring to the withdrawal to the ICC as a political question or decision in my...
Your Honor, let me just clarify what I said. I was referring to the matter of extending cooperation to the ICC. That is what I said, na political in character, whether we will cooperate or not. So that's basically, well, as I said, a political decision. That's why I had to explain from my end the legal position, because the legal position will have a very significant bearing on the matter of making a political decision.
Well, since it was the Senate who ratified our membership for the ICC, would it be also the concurrent with Senate whenever the President withdraws from the ICC? Should there be a concurrence of the Senate?
It's an unresolved issue, Your Honor. Kasi yun pong concurrence na binigay ng Senate dito po sa ating pag-join sa Rome Statute or the ICC did not contain any such condition na kung sakali na mag-withdraw ang Republic through the Executive Department, through the President, ay kakailanganin din po ng concurrence ng Senate. Pwede nyo pong gawin yon as a matter of fact. The Senate can do it if it wants to, na kung magbibigay sila ng concurrence, yung kanila pong resolution granting the concurrence may include, if they wish, a condition na kung mag-withdraw sa treaty or whatever agreement, ay kakailanganin din ng concurrence of the Senate. But in this particular case po of the Senate concurrence on the ratification of the Rome Statute, wala pong ganong klaseng condition. Kaya po the President had that discretion to withdraw even without the concurrence of the Senate.
Before I recognize Congressman Lagman, just to follow up on the question of my co-chair, Abante, again, for the Solicitor General. Sir, you said that it is a political question, so my question is, if the House approves the 3 resolutions and the Senate approves its similar resolution, will the government agencies like your office and the DOJ still wait for the decision of the President, regardless of the resolutions passed by the House and the Senate?
Certainly, Your Honor, because your resolutions urge the President to cooperate. So the final say of whether, in fact, the government will cooperate will be with the President. Yours is an expression of sentiment. That is how you feel about it. But that is not something that is binding. It all depends on the final decision of the President whether he will grant your request that we cooperate. Nasa kanya po yun. And he has repeatedly declared, ito nga po yung sinabi ko earlier, na we cannot give our cooperation to the ICC prosecutor. Nasabi niya na po yun several times. Now, if he will think twice because of these resolutions coming from the Congress, siya po ang magde-decide nun.
Thank you, Solgen Guevarra. I would now recognize Representative Edsel Lagman.
Thank you, joint chairpersons. I would direct my questions to the good Solicitor General, who used to be the Secretary of Justice of former President Rodrigo Duterte. In your presentation, Solicitor General, you delineated jurisdiction into 2 aspects. 1, over the offense, and 2, exercise of jurisdiction. Is that correct?
That is correct, Your Honor.
Now, with respect to jurisdiction over the offense, you conceded that the ICC has jurisdiction over the offense alleged in the complaint filed before the ICC. Is that correct?
Yes, Your Honor. During the period when the Philippines was still a member. So that's from 2011 up to 2019, when our withdrawal became effective.
But it is admitted that the cases were filed during that span of period when the Philippines was still a state party to the Rome Statute. Is that correct?
I wouldn't say cases were filed. Complaints were filed.
Yes, a complaint or a case is similar. I'm just trying to make it understandable to the layman that a complaint is a case.
Not exactly, Your Honor, but we admit na meron pong mga certain groups na nag-file ng complaints before the ICC, but the government did not come to know about these complaints. We were never notified about the existence of these complaints when they were filed.
But subsequently, the government was aware of these complaints.
Yes, when the ICC prosecutor announced that an inquiry was being conducted by the prosecutor.
And when was that announced?
I think that was in 2018 when the ICC prosecutor announced that there was a reasonable basis to proceed.
And that was before the effectivity of the withdrawal of the Philippines from the Rome
That is
Statute.
correct, Your Honor.
Okay. So that is nothing much to debate on. The government, through the Solicitor General, admits the jurisdiction of the ICC over the covered cases. Now, let me go to the next aspect of the jurisdiction as you have delineated, and it is the exercise of jurisdiction.
Yes, Your Honor.
And you said that the exercise of jurisdiction of the ICC lapsed because of delay in the prosecution made by the ICC. Is that correct?
Yes, Your Honor, because the request for authorization to commence an investigation was filed by the ICC prosecutor in May of 2021. He requested authorization to commence investigation.
But prior to that, there was already an examination being made.
Well, inquiries...
As you have said.
Yes, Your Honor, inquiries being conducted by the prosecutor from all possible sources, open sources, media, newspaper reports. The government had nothing to do with it, Your Honor.
Okay. Is there any rule or article in the Rome Statute which provides the time frame within which the ICC or its prosecutors should commence its investigation and exercise of jurisdiction?
There is none,
none.
Your Honor.
There
is none.
There is none. So it appears that the allegation of the government that the ICC jurisdiction has lapsed has no leg to stand on in the Rome Statute.
That is not correct, Your Honor, because I am talking about exercise of jurisdiction. When is that triggered? And it is triggered, according to Article 13, when the ICC prosecutor initiates an investigation.
Okay. And what kind of investigation should that be?
That is precisely the subject of his request with the pretrial chamber to commence an investigation.
Is that the preliminary examination or the preliminary investigation?
We interpret that, Your Honor, to mean the preliminary investigation.
So prior to that, there was already a preliminary examination and exercise of the jurisdiction of the ICC and its prosecutors. Now, don't you think it is an exercise in futility of admitting that there is jurisdiction over the offense, and there can be no more exercise of jurisdiction because it has lapsed?
No, Your Honor, there is no inconsistency between that. As I explained earlier, the Rome Statute tries to balance certain considerations. One is the sovereign right of the state to withdraw if for some significant or important reasons the state wants to withdraw. That is a sovereign right.
Okay.
And the other interest that needs to be balanced is the ICC's effort to end all impunity. So that is why meron nga pong 1-year period na provided
We will go to
under the
that.
ICC.
We will go to that 1-year
Yes,
period.
opo.
I would submit to chairpersons that it is truly an exercise in futility that you adopt jurisdiction over the offense and you frustrate the exercise of jurisdiction because it has lapsed, particularly so when there is no rule in the Rome Statute with respect to the time frame within which the ICC or its prosecutors should act. Now, may we know whether the state party to the ICC, like the Philippines, would have concurrent obligations as well as residual obligations?
Ang tinatanong niyo po ay ang ICC or ang member state po ba? Ang tinatanong niyo?
Yung member state. The member state of the Rome Statute, which created the ICC, thus the member state like the Philippines have concurrent obligation when it is still a member, or when it is still a state party, and has residual obligations after its withdrawal becomes effective.
Yes, Your Honor, definitely. Habang siya ay miyembro ng ICC, naturalmente lamang po na meron siya mga certain obligations to perform as a state party to the Rome Statute. At meron din po siyang residual na obligations like halimbawa po yung mga contributions, mga financial contributions. Kahit na po siya ay nakapag-withdraw na, kung meron pa po siyang mga financial obligations, ay patuloy pa po niyang kailangang i-discharge yung ganong klaseng obligation, which is residual after the effectivity of its withdrawal.
Okay. Maliban sa financial obligations, meron pa ba na residual obligation ang isang state party na nag-withdraw na with effectivity?
Maring mayroon pa po yung sinasabi nga na residual obligation to cooperate. Opo. Pero yun pong obligation na yun ay hindi na magmamatter kung talagang effective na po ang kanyang withdrawal.
Ang gusto mo, hindi na residual yun kung effective na yung withdrawal. Ang residual ay after the effectivity of the withdrawal. Ang sabi mo ay merong residual obligation with respect to financial obligations.
Yes.
Meron ba bang ibang obligasyon?
Kung ang tinutukoy niyo po yung ay after the effectivity of the withdrawal, ay wala na pong legal duty to cooperate.
Wala na. Nabasa ba ho ninyo? Palagay ko, nabasa naman ninyo yung
Article 127. Your
Article 127.
Yes, sir.
Ano sinasabi dito? Let me quote again. This was quoted previously. A state shall not be discharged by reason of its withdrawal from the obligations arising from this statute while it was a party to this statute, including any financial obligations which may have accrued. Its withdrawal shall not affect any cooperation with the court in connection with criminal investigations and proceedings in relation to which the withdrawing state had a duty to cooperate and which were commenced prior to the date on which the withdrawal became effective. palagay ko, is my reading of the subject section 127 accurate?
Very correct, Your Honor, especially yung last part na sinabi nyo, and which were commenced prior to the date on which the withdrawal became effective. Kaya nga po sinasabi ko, yun nga pong na-commence ay nangyari po noong 2021 na tapos na po ang effectivity ng ating withdrawal. Kaya nga po hindi siya applicable, Your Honor.
Ikaw mismo nagsabi na nag-commence yung preliminary examination.
No. Your Honor.
I can appeal to the records of the case. You said that the preliminary, the examination mismo ay nag-commence before the effectivity of the Philippines withdrawal. But the request for a preliminary investigation came after.
Yes.
Yes, correct.
Yun nga po yung ating bone of contention dahil nga po ang interpretation ng government yan ay preliminary investigation ang tinutukoy. Kaya nga po humingi ng authorization pa ang prosecutor to commence his preliminary investigation.
Okay.
Yung pong preliminary examination, sa kanya lang po yun eh. Sa parte lamang po ng prosecutor yon. Siya lamang po ang dumidiskarte doon. Pardon my word. Pero hindi pa po involved ang ICC chamber doon sa time na nangangalap ng ebidensya ang prosecutor. Hindi pa po involved ang chamber ng ICC. Kanya lamang pong sariling effort yon ng prosecutor.
Well, sa palagay ko naman, yung examination ay yun ang pagsisimula ng pag-imbestiga ng prosecutors ng ICC. And they will not proceed without the go signal from the ICC. Kaya we are trying to make a distinction which should not be made. Just so to escape our obligation to cooperate. Ngayon, palagay ko naman alam ng Solicitor General ang Philippine jurisprudence on jurisdiction.
Yes, Your Honor.
And once jurisdiction is laid or attached with the filing of a complaint, whether in a civil or criminal case, that jurisdiction continues unimpeded until there is a pronouncement by the court of its final judgment and its enforcement of its decision. Hindi ba totoo yan?
Tama po yan sa ating judiciary under our legal system. Pero ito pong sa ICC, ito po ay covered ng isang treaty. Kaya po yung ating jurisprudence on jurisdiction does not necessarily apply to an international treaty like the Rome Statute.
Yung bang interpretasyon ng gobyerno doon sa Article 127 ay salungat sa ating jurisprudence na sinusunod sa Pilipinas, na ang jurisdiction, pag iyan once laid, that survives, and that should not be impeded, even by any delay or irregularity in the process. Iyan ang mga desisyon ng ating Korte Suprema. At iyan din ang linalaman ng Article 127, because yung Article 127 did not make any distinction whether it is yung initial examination or preliminary investigation o yung trial mismo before the ICC.
Yun pong sa parte ng ICC ay meron pong, there are specific articles of the Rome Statute that deal with the exercise of jurisdiction. Yun nga pong sinabi ko na Articles 12 and Articles 12 and 13. So very specific po yung exercise of jurisdiction under the Rome Statute. Kaya nga po hindi natin magamit ng exactly kung ano po yung jurisprudence are under Philippine law. Kasi sa atin po ay, kumbaga, sa rules of court natin po iyan, and jurisprudence. Pero ito po ay treaty, kaya po hindi siya talaga applicable. Yun po ang sinusunod natin, yung Articles 12 and 13. Pero kung meron po kayong ibang interpretasyon kung ano ang ibig sabihin ng investigation being commenced by the prosecutor, kung ang inyo pong opinion ay pati preliminary examination stage ay kasama noon, then that is your interpretation, Your Honor. Kaya lamang, yun pong decision ng ICC Appeals Chamber na nangyari po noong July of 2023 ay maliwanag na maliwanag pong explain noong dalawang members of the Appeals Chamber na yun pong pag-exercise ng jurisdiction ay hindi na trigger on a timely basis. At yun po ay makikita natin doon sa dissenting opinion ng mismong presiding judge ng ICC. Okay. Unfortunately, yun pong 3 other members of the Appeals Chamber did not make any statement at all about the issue of jurisdiction. Yung pong dalawang minority, ang siyang mayroong very strong statement na hindi na exercise ang jurisdiction at the proper time. At hindi naman po pwedeng forever, perpetually, na nakahang yung ganyang klaseng threat sa Philippine government. Kaya po, ganon ang kanilang naging decision.
Ito naman mga articles you have cited, good Senator, Solicitor General, ay article, ano ngayon?
12 and 13 po.
12 and 13.
Preconditions to the exercise of jurisdiction.
Ito naman ay na-modify.
Hindi pa po siya na-modify.
Na-modify yan. Mismo sa Rome Statute, doon sa Article 127 on withdrawal.
Hindi po siya minomodify kasi separate po yung 127 eh.
Natural. Pero a subsequent article, in our interpretation, a subsequent article can be construed to modify a previous article. At dito naman sinasabi na kailan mag-cooperate ang isang estado kahit na naging effective na ang withdrawal. And that is very clear sa Article 27, which is subsequent to Article 12 and 13. Now, when you were the Secretary of Justice, were you privy to the appeal which the Philippines made before the ICC?
Yung sa appeals chamber po, I think I was already the Solicitor General at the time that the appeal was made. I was already the Solicitor General at the time.
So you were not privy to the appeal?
Well, I am privy to the appeal because ako po ang representative ng Republic of the Philippines.
Iyan nga ang gusto kong ma-underscore. You were the principal on behalf of the Philippines in that appeal. And as lawyers, or even as laymen, when we appeal, we are expected to respect the appeal, whether it is for us or against us. In this case, the appeal by 3-2 was against the Philippines appeal, where the court reiterated its jurisdiction. Is that correct?
No. No, dahil wala nga pong aspect yung decision ng appeals chamber na nag-deal with the issue of jurisdiction. Kaya nga po yung issue ng jurisdiction nakahang until now. At yun po ang basihan kung bakit hanggang sa ngayon ay pinapangatawanan ng Philippine government na walang jurisdiction dahil hindi na-exercise po yung jurisdiction na yan at the proper time. Wala pong aspect yung decision ng appeals chamber dealing with the issue of jurisdiction. Kasi iniskirt po yan nung tatlong, yung five-member chamber, yung tatlo po na majority did not make any statement at all about the challenge to jurisdiction. Ang sinabi lang po nila, this is not the proper time to address the issue of jurisdiction. Kaya po nakahang yung issue ng jurisdiction until now.
Yung principal question ng ating gobyerno hinggil sa appeal ay walang jurisdiction ang ICC over the country because it has already withdrawn from the Rome Statute. Is that correct?
Hindi lang po yun.
Isa yan.
Isa po yan.
Isa yan.
Isa po yan.
Ngayon, in essence, ano ba yung decision, majority decision ng ICC?
Ang essence po ay pwedeng ipagpatuloy ng prosecutor ang kanyang investigation.
Okay. Iyan nga. So, in that sense, natalo ang Pilipinas. At obligasyon ng Pilipinas, tayo na nag-appeal, sundin natin ang desisyon ng ICC. Otherwise, bakit mag-a-appeal pa tayo kung hindi natin susundin ang desisyon? Ang desisyon ay ipagpatuloy ang investigasyon. Kaya ang desisyon ay kailangan din mag-cooperate ang Pilipinas sa investigasyon. I think we should not be a renegade in the international community, but we should subscribe to the principle of the rule of law. Pag nag-appeal ka at tatalo ka, tanggapin mo ang desisyon at sundin mo.
May I say something about that?
Yes.
Tayo naman po ay sumusunod doon sa decision na yon ng appeals chamber. Ano po ba ang decision ng appeals chamber? Mr. Prosecutor, you may continue your investigation. So, ang Pilipinas naman po, hindi naman pinagbabawalan yung prosecutor na magpatuloy ng kanyang pagsisiyasat ng investigation. Dahil yun po ang decision ng appeals chamber. Hindi naman po natin siya pinagbabawalan na magsiyasat. Ang sinasabi lang po ng Philippine government, dahil may issues kami ng jurisdiction na hindi na settle dyan sa decision na yan, wag kang mag-expect ng cooperation from us. Pero hindi kita pinipigilan na mag-continue ng iyong investigation dahil yan ang naging decision ng appeals chamber. You can investigate in whatever way you want. You can talk to any person you want. You can interview any witness you want. It's up to you. Ang sinasabi lang po natin dito, but do not expect cooperation from the Philippine government. Yun lamang po. Hindi naman po natin sinusuway yung decision ng appeals chamber. Hindi po natin pinagbabawalan ang ICC prosecutor to proceed with his investigation.
Okay. Hindi ba isa sa mga issues ng Pilipinas doon sa appeal ay gusto nating pagbawalan ang investigasyon ng ICC prosecutors dito sa loob ng bansa?
Sinasabi po kasi natin ay hindi admissible yung kaso dahil nga po ang may primary responsibility to investigate ay ang sarili nating national institutions. Kaya po hindi tayo pumapayag na sila ay mag-investigate. Pero ganyan nga po ang naging decision. Kaya po, sige, di mag-investigate kayo kung gusto niyo mag-investigate.
Mag-investigate hanggang dito sa Pilipinas.
Opo, syempre.
Siyempre. Ang gusto lang niyo sabihin,
Congressman Lagman, can I just make it clear in relation to what you were asking? Kasi hindi masyadong malinaw sa akin eh. So yung pinag-uusapan natin ngayon na Solicitor General na ayaw makipag-cooperate ng Philippine government sa ICC pero pinapayagan sila mag-imbestiga. Yun pa ang gusto mo sabihin?
Yes, hindi naman po natin pinagbabawalan na mag-investigate yung prosecutor dahil yun po ang...
Therefore, naniniwala din kayo na may jurisdiction ang ICC na mag-imbestiga kahit na hindi mag-cooperate ang gobyerno.
Kahit po hindi makipag-cooperate ang government, ang basihan po kasi ng lack of cooperation ay dahil nga po until now ay china-challenge pa rin natin ang jurisdiction ng ICC dahil po hindi niya na-exercise yung jurisdiction na yon sa tamang panahon. Hanggang ngayon po ay yun ang ating pinapangatawanan. At wala pong aspeto yung decision ng Appeals Chamber tungkol doon. Kaya hanggang ngayon po ay yun ang ating minemaintain.
So, ibig sabihin na firm pa rin kayo sa inyong paniniwala na dahilan sa nag-withdraw ang Philippine government noong panahon ni President Duterte ay dapat hindi mag-cooperate ang Philippine government at dapat hindi mag-imbestiga ang ICC.
Hindi po. Ang sinasabi po namin, there is no legal duty on the part of the Philippine government to cooperate. Yun lamang po ang sinasabi namin.
okay. Maliwanag naman yun, Mr. Chairman, na ang sinasabi ni Solicitor General, pwedeng mag-imbestiga ang ICC, conduct the preliminary investigation dito. Makalagay ko, dito naman ang mga ebidensya, dito yung mga testigo. Pero ang gobyerno ay hindi magko-cooperate sapagkat wala silang legal duty. Kahit na admitted naman na doon sa Article 127, may legal duty ang Pilipinas to cooperate in the investigation. Ngayon, ang sabi ng Solicitor General, Mr. Chairman, ay meron pang question sa admissibility or yung complementarity.
Jurisdiction and admissibility po.
Okay, okay. Yung sa complementarity, wala nang problema ba yun?
Hindi po. Until now, we maintain our position kasi na ang may primary responsibility ay ang ating mga national institutions pa rin.
Okay. Pero doon sa complementarity, hindi naman tinutukoy yung the whole gamut of the judicial system in the Philippines that it is working or it is not working. Ang tinutukoy lamang ay tungkol dun sa kaso before the ICC kung yung bang respondents ay being prosecuted or being tried in Philippine courts. That should be the context of complementarity. Si former President Duterte ba at sila, yung mga kanyang major correspondents ay meron ng prosecutor na Pilipino, prosecutorial office na may nakapending na reklamo laban sa kanila na iniusig.
As far as the former president is concerned, Your Honor, wala pa po dahil wala pong nagpa-file ng complaint against him. Nung time na siya ay presidente, that's understandable dahil siya po ay may immunity from suit. Pero ngayon po na hindi na siya presidente, wala namang nagpa-file ng complaint sa kanya.
Yung gobyerno ba mismo, yung prosecutor mismo, ay hindi pwedeng mag-file on their own sapagkat merong krimen na naganap sa Pilipinas under our laws and our international law?
Ang ating usual procedure po ay merong complainant, halimbawa yung biktima, kung sila po ay nag-allege na ang presidente ang siyang pasimuno ng lahat ng ito, ay sila po ang dapat na mag-file ng kaukulang complaint.
Motu proprio, ang gobyerno hindi pwedeng mag-file? Pinagbabawal ba yan?
Kasi po hindi po yun ang ating normal na proseso na mag-iimbestiga, magko-conduct ng preliminary investigation ang ating prosecutor nang wala namang nakahain na reklamo sa kanyang opisina. Ano po ang kanyang iimbestigahan kung wala naman pong nakahain na reklamo?
Okay. Yung bang ibang mga respondents maliban sa former president wala rin kaso sa prosecution sa prosecutor's office.
Depende po sino po bang mga
Hindi,
tao ang
si Senator Bato ba meron?
Wala po.
Wala.
Wala naman pong nag-file ng any complaint against him.
Okay. Meron ba naman na nakapending na kaso sa husgado sa Pilipinas laban kay former President Duterte at mga kanyang correspondents hinggil doon sa crimes against humanity tungkol sa deadly war on drugs?
Let me just clarify this, Your Honor. Kasi yung iniimbestigahan po ng ICC ay ang Philippine situation in general. Wala naman pong any specific persons na tinutukoy ang ICC prosecutor sa panahon na ngayon. Ano po? Kaya nga po siya magko-conduct ng investigation with the end in view of specifically identifying certain individuals at a later time. Pero wala pa po tayo doon eh. Wala naman hong ina-identify ang ICC prosecutor na specific persons na siyang papaharapin sa ICC trial chamber kung kinakailangan. Sa ngayon po, wala pa po tayo doon sa stage na yon. It's the Philippine situation being looked into by the prosecutor. Kaya po, hindi po parang wala pong parallelism na tanungin kung meron na po bang domestic complaint against Senator Bato or meron na po bang local case against the President. Kasi even the ICC po, wala naman po silang ina-identify pa na certain persons na kanilang lilitisin sa trial chamber.
Doon ba sa mga complaints, gusto mo sabihin ng complaints, hindi kaso, complaints na pinail sa ICC, meron bang mga tinutukoy na respondents?
Actually, hindi po namin nakita at all yung mga complaints na yon na inihain sa ICC prosecutor. We were just informed na merong investigation or examination na gagawin ang ICC prosecutor. But we never saw yung complaints na yon. Nalaman na lamang po namin sa mga media reports na ang subject matter noong mga complaints na yon ay mga certain individuals like the former president, I think certain PNP officials, Senator Bato de la Rosa. Yun po ay nag-gather na lamang namin from media reports. Pero hindi po yun as in binigyan ng kopya, ng reklamo, ang Philippine government para po makapag-comment naman kahit papano ang Philippine government. Hindi po nabigyan ng ganong klaseng opportunity ang Philippine government nung time na nag-gather po ng facts or ng evidence yung prosecutor.
Ang gusto mong sabihin, Solicitor General, at the initiative of the Philippine government or its officials, hindi kayo kumuha o humingi ng mga complaints sa inyo para malaman ninyo kung ano talaga ang linalaman ng mga complaints?
We did. As a matter of fact, we requested copies of these complaints.
And you were also given copies of the complaints?
No, we were not given copies of these complaints. Until now, Your Honor, I have not seen a copy of any of these complaints.
Sino ba sa mga resource persons ay may copy ng mga complaints na ito?
Mr. Chair, copy of the...
Complaints sa ICC?
Kami, Mr. Chair, may copy kami ng complaint namin and of course the complaint of Attorney Sabio. Maybe Attorney...
Pakibigyan mo nga si Solicitor General para malaman niya kung anong linalaman ng mga complaints na yan.
Yes, Mr. Chair.
At bigyan mo rin ang joint committees ng kopya ng mga complaints na yan.
Yes, Mr. Chair.
Pinag-uusapan natin na kayo lang ang nakakakita.
Yes, Mr.
Okay.
Chair. At Tsaka, I'd just like to add, Mr. Chair, if I may, yung Department Circular 20-A lang ng DOJ about motu proprio investigation if in the information of the DOJ a crime has been committed. Parang wala akong nakita na need of a complainant dito. And in fact, the PNP is even motu proprio also required to investigate under the Department Circular if kahit walang complainant, if they feel that there's a crime being committed. So yun lang, Mr. Chair, gusto kong i-add thousands of deaths. And I think that's enough information to at least initiate an investigation despite the absence of the
Attorney
appeal.
Larry, ilan
Mr.
po ang complaint na na-file ninyo?
Sa ICC po, isa po. But it involves about 7 families of the EJK victims, and of course, Rise Up for Life, the church NGO, Mr. Chair, who initiated it.
Are there others nag-file ng complaints sa iba? For example, like Attorney
Sabio, yes, Mr. Chair.
Meron po ba?
And there could be others who filed, but because probably for some reason, like they are afraid to be known, they did not announce it. But it's really possible that there are many other complaints filed, either before Attorney Savio or after 2017. We don't know. But we have information that there are other victims who went there, except that unlike the Rise Up for Life and Attorney Savio, they did not disclose their identities, Mr. Chair.
So the request of Congressman Lagman na bigyan nyo ng kopya si Solicitor General Guevarra on the complaints, can you do that?
We will do that, Mr. Chair.
And please give a copy to the committee also.
We will do that,
Mr.
Mr. Chair. Salamat.
Gusto ko lang pong balikan yung tinatanong kanina ni Honorable Edsel Lagman. Yun po kasi doon po sa mga libo-libong insidente na mayroong napatay sa mga police operations na may kinalaman sa war on drugs, ang PNP po, nandito ang representative ng PNP, automatically po, yung kanilang Internal Affairs Service ay nagko-conduct ng kanilang sariling investigation. At kung sa tingin nila ay merong parang lapses or hindi tamang pag-conduct ng kanilang, let's say, police operations, ay pinapatawan naman po nila ng kaukulang disciplinary action or kung kailangang i-file sa kaso sa DOJ ay ginagawa nila. Pero nung pong time na ito ay naging mainit na issue, ang ginawa po ng DOJ, ako po yung Justice Secretary at that time, hiningan po namin ang Internal Affairs Service ng PNP ng lahat ng kanilang investigation reports tungkol sa mga killings na incidental to the conduct of police operations. At sila naman po ay fortunately nagpa-unlock. So, ibinigay po nila sa DOJ at least 56 cases na ang tingin nila ay may possible liability yung mga police officers involved. On the part of the DOJ, nung matanggap po namin yun, Congressman Edsel, ang ginawa po namin, dahil yon ay initial examination lamang ng PNP, nirefer po namin sa National Bureau of Investigation for case build-up. Kaya po doon sa proseso na yon, na mayroong sariling investigation, automatic ang Internal Affairs Service, napunta ng DOJ inassign sa NBI para po mag-case build-up. Meron pong mga kaso resulting from that na na-file ang formal complaint sa DOJ for preliminary investigation at yung ibang kaso po ay nakarating sa husgado. So, yun po yung proseso. Hindi naman po talaga as in walang gagawin ang DOJ kundi maghintay. Dito po sa situation na to ay ugnayan po kami sa PNP para po kunin sa kanila yung mga reports ng kanilang initial investigation.
Kung nagustuhan mo ang bidyong ito, huwag mo kalimutang mag-comment, mag-like, mag-subscribe, at huwag mo din kalimutang i-click ang notification bell para updated ka sa mga susunod naming video. Maraming salamat po.